Hello learners, I'm Anubhav Sharma. I'm the faculty for Indian Polity and Governance at Unacademy IS. And today we are going to discuss about a very important topic, that is Part 4 of Indian Constitution, DPSPs. What are DPSPs? Directive Principle of State Policies. What exactly are we trying to achieve in this lecture? See, I would imagine that you already know that when we talk about Part 1 of Indian Constitution, it talks about Union and its territories. Part 2 talks about citizenship, and Part 3 talks about fundamental rights. Then we have Part 4 of Indian Constitution that talks about directive principles of state policies. If you think about it, Part 3 of Indian Constitution is a way by which Constitution is talking to citizens of India because it is communicating what exactly are those fundamental rights which are intrinsic and core to your existence. Something that Constitution is guaranteeing will be protected by the Constitution. But in Part 4, Constitution is actually talking to the state. Constitution is talking to union legislature, union executive, state legislature, state executive, not just of current government, current state, but of all future states. In this regard, what exactly do we know about these DPSPs? On one hand, fundamental rights is the place by which Constitution is trying to establish political freedom for everyone. If you try to understand fundamental rights, what exactly we see? We see it talks about right to equality, right against discrimination. It ends preferential treatment like titles, zamindari system. It brings about special rights to minorities. It talks about religious rights, religious communities' right. In this regard, by and large, if you think about it, the main emphasis of fundamental rights is to protect every citizen's individual rights. But at the same time, Constitution would want to achieve some socialistic goals by which we are able to bring about welfareism in India. In this regard, when we analyze Part 4 of Indian Constitution, what do we see? It is Part 4 of Indian Constitution where Constituent Assembly has kept India's welfare goals, India's socialism, India's socialistic goals. In this regard, by and large, this is something that I would imagine all serious aspirants of UPSC already know about. That well, this is what DPSP is about. These are certain goals that are being given by the Constituent Assembly to the state, not just of today, but of the future as well. These are the directions in which we would want state to make policies. And that is why it talks about equal pay for equal work for men and women. It talks about special rights to be created, special provisions to be created for the people who are sick, for the people who are senior citizens. We have a DPSP that talk about that workers should be given more right with respect to decisions of the management in factories. But at the same time, if we were to analyze DPSPs, we see apart from it being the place where we are going to keep socialistic goals, there were other factors that were involved, that were there, which led to creation of Part 4 of Indian Constitution. In this regard, generally, I see students who understand about some of the basic aspects of it, but they don't know about these factors. And even in books, these factors are not covered and explained in detail. So in this lecture, the intent is that we are able to understand those major factors which led to creation of Part 4 of Indian Constitution, apart from the obvious reasons. In this regard, what exactly was the first factor? The first factor was that Constituent Assembly wanted to accommodate some of the rights in DPSPs which they were not able to accommodate in Part 3 of Indian Constitution. There were certain rights which they wanted to guarantee under fundamental rights, but because it was not possible for them to guarantee it under fundamental rights, they decided to keep it in DPSPs. For example, when you talk about something like a right to education, which was Article 45, a DPSP. See, if you think about it, at the time of independence, when the Constituent Assembly was functioning, indeed a lot of discussion and debate happened with respect to what should and should not become a fundamental right. But by and large, one would imagine there must be consensus with respect to something as simple as right to education. You would want that state should guarantee it as a fundamental right to all children from the age 6 to 14, their right to get primary education by state. In this regard, that was indeed the case. There was this clarity that we should be guaranteeing something like right to education as a fundamental right. But the problem was, we were not having economic capacity to guarantee it as a fundamental right. Think about it. The very moment we are making something like right to education as a part of Part 3 of Indian Constitution, what exactly are we saying? That now it has become justiciable. Now it has become something for which, if a child is not able to go to school, if a child is not having a primary school where he can actually go to within his village, what exactly is the idea? It essentially will lead to violation of his fundamental right. As such, it was always not proper that we are having a system where we essentially allow students, or for that matter people, to be able to go to High Court and Supreme Court, something for which the government, the state of India was not prepared, be it in terms of economics, or for that matter, if you think about it, even with respect to administrative capacity. Think about it. The very idea that we need to have school in every village of India is not only an economic question but also an administrative question. We will need to have proper infrastructure in place, proper books in place. Not just that, we will need to have what? We will need to have at least one primary school teacher, which is there in every school of India. In this regard, for the country where literacy was less than 20% in 1950, it was creating a very big administrative issue as well. As such, what we thought? Well, right to education is certainly something that we would have loved to give as a fundamental right, but then we are keeping it as a goal of future. But till that time, it is going to be in DPSPs. It is going to be a part of Part 4 of Indian Constitution under Article 45. In this regard, what we know is the fact that subsequently we were able to make it into a fundamental right under Article 21A. Now we know it is the fundamental right of every child to get primary education under 6 to 14. And this is how we were able to achieve it, because it was always there in the Constitution in the non-justiciable part, that is DPSP, but then it became a part of justiciable part of Indian Constitution, that is fundamental right of every citizen. Similar to it, so what do we see? We see right to work was not something that we can guarantee as a fundamental right at that time, for the very simple reason we were not having the capacity by which we can ensure that if at all you are not getting work, state is going to give you some sort of unemployment compensation, again because of economic constraints. In this regard, today what exactly we see? What we see is right to work is being guaranteed in form of MG Narega. What do we have? We essentially have this policy of state that every person who's looking for work and is not able to get work will need to be compensated for 100 days. And if at all the person is not getting work for 100 days, state is going to give him the money for 100 days, salary for 100 days. This is a way by which we essentially are able to create a right to work, if not a fundamental right, at least a legal right. In this regard, what exactly we see? One of the very important reasons that we were having DPSPs was the fact that we wanted to keep certain rights that we weren't at the time of independence, at the time of creation of Constitution, were able to promise as a fundamental right. But subsequently, some of the rights became fundamental rights, like right to education, while some of the other rights, like right to work, are now legal rights. Fine. The second reason why we essentially needed DPSPs, and that was so that we are able to keep some politically controversial issues. समझते हैं इसको. So when you talk about an issue like Uniform Civil Code, at the time of independence, it was a very controversial issue. Why exactly it was a controversial issue? The first reason was that due to creation of Pakistan, Muhammad Ali Jinnah had created a lot of insecurity among Indians, basically Indian minorities, and that too Indian Muslims. What exactly was the insecurity? He said that what India is going to do is not only to have uniform civil code, but also uniform criminal code, and this essentially is going to lead to what? A country with 80% Hindus making laws in a manner in which personal laws of the religions will not be protected. Muhammad Ali Jinnah argued India is going to become a secular country where they are going to make policies, and they are going to say that we are not going to keep religious considerations in our mind while making policies for the reason we are secular, and in the process, majority, that is Hindus, will get their way. In this regard, slowly and steadily, minorities, specifically Muslims, are going to lose their identity. उनकी जो identity है वो lose करने लगेंगे धीरे धीरे over the period of time. In this regard, what it had done was to make mainly Indian Muslims a bit insecure with respect to the term Uniform Civil Code. I would imagine you know Uniform Civil Code means that even with respect to personal laws, even with respect to ways in which marriage occurs, divorce occurs, even with respect to adoption, property dispute, what is required? State is going to create some uniform laws by which for every religion these matters will be settled. In this regard, the fear among Indian Muslims was the fact that it is going to, in an unfair manner, unreasonable manner, interfere with their religious practices. Something that we need to understand is at the time when Constituent Assembly was discussing, there was a kind of consensus that indeed we need to have both uniform criminal code but as well as uniform civil code. But due to this insecurity, it was decided perhaps time has not come that we essentially are able to make it as a justiciable part of constitution. But at the same time, we need to work towards what? Work towards ensuring that UCC is a goal for the future. So we decided a politically controversial issue like UCC can be kept in DPSP under Article 44. And state will endeavor to establish an environment where now uniform civil code can actually be created as a justiciable part of the constitution. There was another factor that was considered at that time, and the factor was, isko samajhiyega. So if you think about it, for the first time, India was going to become a democracy right after creation of the constitution. In this regard, a lot of changes are going to come. All the people are going to, for the first time, have universal adult franchise. Every adult person will have right to vote. In this regard, one of the fear that was there in the minds of some of the members of Constituent Assembly, and for that matter, number of political experts, was the fact that is India ready to be a democracy? For the very simple reason, democracy is about people exercising their democratic rights in order to practice democratic values. If at all we see that there are so many changes that are happening in India, where now people are supposed to think beyond their tradition, beyond their caste, beyond their region, in order to think about equality, democracy, something to which they were by and large oblivion to in the way in which they used to live their socio-economic life. Wouldn't it be too much that we are also expecting them to change their religious cultural ways in which they engage in marriage, adoption, divorce as per what state decides? कहीं ये बहुत ज्यादा तो नहीं हो जाएगा कि स्टेट इंटरफेयर कर रहा है इन मैटर्स ऑफ रिलीजन, स्टेट इंटरफेयर कर रहा है इन मैटर्स ऑफ रिलीजियस प्रैक्टिसेस, एंड इन द प्रोसेस people might start revolting against the system. मेरी बात समझ में आ रही है? In this regard, what exactly we did? We decided perhaps time is not right that we essentially should have UCC as a justiciable part of constitution. So what we'll do, we essentially will make it Article 44, we will park it in DPSPs and we are going to keep it as a goal for the future. आगे के लिए हमने इसको एक गोल रखा कि आगे चल के हमें ये गोल अचीव करना है. Fine. Then there were other reasons as well. The third reason was we wanted to accommodate some of the Gandhian ideas. इसको थोड़ा समझते हैं. So if you think about it, one of the most important actors, one of the main important actors which brought India its independence was Mahatma Gandhi. And the manner in which we had went about in our freedom struggle, Satyagraha, civil disobedience movement that was given by Mahatma Gandhi was at the core of it. So one can argue Gandhian values had dominated our freedom struggle by and large since the coming of Gandhi into India. In this respect, at the time of independence, there were a number of Gandhian followers who were also part of Constituent Assembly. These Gandhian followers, these Gandhian members wanted many of these Gandhian ideas to become part of Indian Constitution. In this regard, while it makes sense that we essentially can adopt Gandhian ideas, it perhaps was not in the making of a liberal constitution, a cosmopolitan constitution, to actually make some of the Gandhian ideas to be justiciable part of Indian Constitution. For example, Gandhiji believed that it is very important that we put a ban on consumption of alcohol for the reason Gandhiji felt that when you talk about alcohol addiction, mainly in the poor family, it has a tendency by which it can destroy a family and it makes a family to always live in poverty for the reason the man of the family who is the breadwinner will spend all the money in consumption of alcohol without taking care of his family. As such, it to be a moral responsibility of society, it bans alcohol, and it to be a very high, a very big moral sin if at all we essentially are having people who consumes alcohol. In this regard, Gandhian value, a Gandhian idea tha that alcohol consumption should be banned. In this regard, if you think about it, in an independent India, in an India where we essentially are going to have constitutional democracy, perhaps keeping alcohol ban to be a justiciable part of constitution was not a very wise idea. And there are a number of reasons for it. The first reason is when you talk about something like alcohol, consumption of alcohol can be looked upon as something which changes from society to society. India has a very diverse society where there are diverse sections. We are having people who essentially are having their regional cultural practices, ethnic cultural practices. In many of the regions, many of the communities, we have alcohol to be a very important aspect of their cultural practice. In this regard, it will not be fair that we essentially are imposing Gandhian idea on all sections of India when alcohol can actually be looked upon in different ways by different people. There was another consideration, and that was alcohol was also a very important source of tax for the government. In this regard, it will again not be wise on the part of government if at all there is complete ban on consumption of alcohol. In this regard, it was decided, you know what, we essentially can park it as a DPSP. We can park it as Article 47, and we will leave it for every state, every province to decide how exactly they would want to go about in terms of banning alcohol. For example, we know that we have two states, a Gujarat hai and Bihar, both of them have banned alcohol. As such, what exactly we see? We see there are states which have not banned alcohol, there are states which have banned alcohol, and almost every state is having their own policy with respect to consumption of alcohol. States are having different legal age to consume alcohol. States are having different taxes that are being imposed with respect to consumption of alcohol. That means states are having flexibility to deal with how exactly they would want to go about in regulating consumption of alcohol. In this regard, it was indeed a very wise decision to park this Gandhian idea under DPSP, where now states are having flexibility to decide how exactly they would want to regulate alcohol. Another Gandhian idea, which essentially was a bit controversial at that time, was the fact that Gandhiji believed there should be a ban on cow slaughter, there should be a ban on killing of milch animals. What was the logic of Gandhiji? Gandhiji believed that when you talk about a living cow, it can feed so many people for so many days. On the other hand, a dead cow will be able to feed few people for only few days. In this regard, he considered it to be a moral sin for a country like India, where so many people were dying of hunger, that we essentially are allowing cows to get killed, we are allowing milch animals to get killed for consumption of meat. As such, he believed it is not right for the state to allow killing of cattle, killing of milch animals. Again, as you may be able to understand that this again was a very controversial issue for the very simple reason, consumption of beef as a food article around the world is not considered to be something which is very controversial. It is something which is by and large considered around the world to be a reasonable food article that people would want to consume. In the same manner, when we look at different cultures in India, what we see, different cultures are having their own practices with respect to beef consumption. In many of the northeastern states, consumption of beef is linked with many of the festivals that are being celebrated. In this regard, again, it would be unreasonable that we essentially are creating a uniform law all across country where we say consumption of beef is not allowed. Keeping that in mind, again, this Gandhian idea was kept in DPSP, by which again we are giving flexibility to states to decide how exactly they would want to go about it. And that is why we are having certain states which have banned consumption of beef, while we are having certain states which have not banned consumption of beef. Again, a very interesting way in which we essentially made use of Part 4 of Indian Constitution DPSP, where we allowed flexibility to every state to go about how exactly they would want to use this direction. Fine. Apart from it, one of the core idea of Gandhiji was Panchayati Raj institutions. Gandhiji believed in India we need to promote Panchayati Raj institutions. Why? For the reason he believed that when you talk about a country like India, it is very diverse, diversity is very high, and diversity is not something which you can see only from state to state. It is visible from region to region, it is visible from district to district, and it is visible from village to village. For a country which is so diverse, invariably you will have every village having their own way of living, having their own necessities with respect to development. In this regard, if at all we are having a top-down approach of policy making, we are having everything being decided by the center, it might have an effect in which we will end up having one fit all policy, and we will end up wasting more than actually gaining more. Keeping that in mind, Gandhiji believed that in India, while people may not be knowing about a top-down democratic model political system like a parliamentary system, people of India have always been aware about grassroots democracy with respect to panchayat. Be it during the time of Britishers, be it during the time of Mughals, be it during the time of Cholas, be it during the time of हमारे जो Mauryans, we know we have history with respect to Panchayati Raj system getting practiced. That is why Panchayati Raj system is not something which is alien to us. It is something which is embedded in India's social practice, social structure. Hence, it was decided, or the opinion of at least Gandhiji was, that why can't we essentially have a panchayat to be a very powerful unit in which they can make decisions for the village, and it should be the duty of state and center to deliver everything that panchayat wants. Gandhiji had imagined village to be a self-sufficient unit where all decisions, all necessities of the village can be taken by the village itself. In this regard, while it may appear to be a very appealing idea with respect to direct democracy, it was also something that was objected to by many of the leaders, including B.R. Ambedkar. B.R. Ambedkar believed the fact that we need to understand what we seek to achieve in our constitution. In our constitution, we would want to end discrimination, we would want to end untouchability, we would want to end gender discrimination, we would want to bring about equality for the women. In this regard, in some ways, we are acknowledging these are some problems that we are having in India. We are having sati, we are having untouchability, Dalits are not being allowed to enter the temple, we are having patriarchy, we are having male chauvinism, we are having discrimination against the backward sections. The whole idea is that state will need to create a new social revolution by which all these social evils can be ended. In this regard, where exactly do we see all these social evils in their worst form? At the grassroots. And the idea of Gandhiji is that we need to empower the grassroots and we need to have a bottom-up approach, perhaps not the best thing to do at the time of independence, where we are trying to bring about, in the words of Granville Austin, a social revolution. In this regard, it was decided perhaps time is not right that we need to have something like Panchayati Raj institution. At the time of creation of the constitution itself, it was kept to be a goal for the future, and states were given the flexibility to decide how exactly they would want to promote and make panchayats powerful. Something which is very good to see that in 73rd and 74th Constitutional Amendment Act, we have given constitutional recognition to panchayat, by which what exactly we have achieved? We essentially have been able to achieve the goal that was given under DPSP, one of the Gandhian ideas. But I hope you understand one of the reasons why we essentially had DPSP was because it essentially became a very important place to park Gandhian ideas. Fine. What exactly was the fourth reason why we essentially decided to have DPSP? And it was that it was supposed to be a manifesto, a model manifesto for the citizens. What do we mean by this? See, the thing is, one of the concerns that Constituent Assembly was having, number of experts around the world was having, that is India ready to become a democracy? For the country where literacy rate was less than 20%, for the country where democracy has never been there because we essentially were always under a monarchical kind of setup before Britishers. In such a country, suddenly we are going to bring about a constitution that talks about democracy, that talks about equality, and above everything else, it actually gives a right to vote to every citizen of India. We essentially would want to give what? We want to give universal adult franchise. In this respect, the fear was that when you talk about democracy, citizens will need to be very responsible with respect to how exactly they choose to vote, how exactly they choose to give power to any entity. It should not be, it cannot be that people are voting not on democratic goals. People are voting based on traditional identities, communal identities. It cannot be, it should not be that people are voting for who exactly is from their caste, that person should be given the vote. Who exactly is from language, that person should be given the vote. Who exactly is talking about their caste or religion, that person should be given the vote, because then perhaps we might end up having communal politics, caste-based politics, something which is not ideal for any democracy. In this regard, the thing that is very necessary is, by and large, there should be what is called as democratization of society that should have taken place before we bring about democracy. In fact, for the people who may not be knowing, someone like even Subhash Chandra Bose had talked about it, spoken about it, that it is necessary that we essentially right after independence are working towards democratization of Indian society so that we start practicing democracy in the right manner. In this respect, what exactly is the idea? DPSP was also thought to be that place where we essentially will have citizens to have something that can be called as a constitutional manifesto. What do we mean by that? I think you must be knowing that every political party is coming up with their manifestos. When these political parties come out with their manifestos, what exactly we see? They discuss about different policies, different promises that they are making to the people who are going to vote for them. Political party will say, well, these are those 20 promises that we are making, these are those 120 promises that we are making. And when an aware citizen looks at these promises, he will decide, should I or shouldn't I give vote to this candidate? In this regard, when you think about it, what is written in DPSPs can also be looked upon a kind of a manifesto. For the reason DPSP says that, well, state should make policies by which it is able to ensure equal pay for equal work for men and women. It can be looked upon as a manifesto promise. If you read about it, it says that state should make policies by which we are able to promote public health. We are able to make special policies for senior citizens. We are able to make special policies that protects educational interest of SC/ST. In this respect, if you think about it, aren't these promises which generally political parties are giving to the people when they are fighting elections? One of the things that we wanted to achieve by having DPSP, that any citizen who reads DPSP is able to get an idea that these are the values for which, these are the reasons for which they should be voting in elections. This is what they should be testing the performance of any government on, how well they were able to achieve objectives given under DPSPs. And that is why it is argued, one of the things that we wanted to achieve was to provide the citizens of India a constitutional manifesto, and that was DPSP. I hope you're able to understand why exactly DPSP is also called as Manifesto for the Citizens. In fact, this is a question that has also been asked in the exam, that DPSP can be called to be a constitutional manifesto, elaborate, explain. And this is what we need to explain. Finally, there was one more reason why it was decided that we need to have DPSPs. What was that reason? It was mainly international experience. What do we mean by that? Made Indian constitution during 1947, 48, 49, 50, during this period, and by that time, number of countries around the world were already independent and they were functioning as constitutional democracies. So one of the luxuries that our Constituent Assembly members were having, we could learn from the experiences of the other. We could study not only what is written in their constitution, but how exactly after creation of the constitution their experience has been. In this regard, interestingly, something was noticed by B.N. Rao. So B.N. Rao had said that when you essentially look at almost all the constitutions of the West, they will always have some aspects of the constitutions which are expected to be justiciable, like fundamental rights, like center-state relations, but many of the provisions were only guidelines that has been provided to the state. That is, these are certain directions that we would want you to work towards, but these are not mandatory. but the manner in which justiciable part of the provisions of the constitution were given and not mandatory guidelines were given, there used to be a lack of clarity कि कौन से mandatory है और कौन से mandatory नहीं है. It was creating confusion. What exactly are the provisions we need to implement and what are the provisions which are only guidelines? In this regard, it used to be a bigger confusion for the judiciary. For judiciary is in the business of interpretation of constitution and ensuring in judicial review all actions of state is as per constitution. In this regard, judiciary in many of these countries used to get confused. Are they supposed to treat a provision as justiciable or not? For the reason, proper distinction between what is justiciable and what isn't was not made by the Constituent Assembly of these constitutions. Learning from their experience, what exactly our Constituent Assembly decided to do? They said that we are going to create a dedicated part called Part 4 of Indian Constitution. And this Part 4 of Indian Constitution, we are explicitly saying, is non-justiciable. Article 37 of Indian Constitution is very clear. Provisions that are given in DPSPs are non-justiciable. They cannot be argued in the court of law. In this regard, what exactly we were able to achieve? We actually made it explicitly clear. Part 4 is non-justiciable. Now, it will not lead to confusion for judiciary in interpretation of the Constitution. As such, this again was a very important reason why we did it. Just an interesting fact, in 1959, a very interesting question came to Supreme Court. The question was that, sir, indeed, we cannot come to court if at all state is not acting as per DPSP. But what if actions of the state are going against what DPSP says? What if state is taking an action which is absolutely against and opposite to what DPSP says? For example, one of the directive principle of state policy is state should be making policies by which they are able to ban alcohol. In this regard, one can argue if at all tax is being increased on alcohol, that's a step towards it. There is prohibition of alcohol, that's a step towards it. You're increasing the legal permissible age to consume alcohol, that again can be a step towards it. But then, let's imagine what is happening in Haryana. One can argue, state of Haryana has actually made it easier for people to be able to buy and consume alcohol. In this regard, we are not saying that state has not taken a step towards it. What we are saying, that state has taken a step which is explicitly opposite to the objective and direction that is given in DPSP. The question is, how exactly court looks at it? Can it be questioned in the court of law that state is acting against DPSP? Supreme Court said no, that also is not allowed. What is not justiciable is you cannot force state to take actions to implement DPSP. What is also not justiciable is if at all state's action is opposite to DPSP. So, in conclusion, what exactly we see? These were the reasons why we essentially had DPSPs getting added in the constitution, apart from the obvious reasons. I would imagine this has really helped the students who are trying to find these answers in books, because generally in books it is not explained in a proper manner in detail. I would imagine this session has been helpful to you. If you have any doubts, please ask in the comments. Thank you.